Hello, my name is Sue Miller. Together with my colleague Ed Davis, I head up the Finance Litigation Group at Stevenson Harwood. Welcome to the first in our series of 4 short videos in which we take a bite-sized look at some of the key themes emerging from the courts over the last 12 months. Each video will be only around 10 minutes long and can be downloaded for viewing at a time and a way that suits you best. We hope that you find them an entertaining and easily digestible route to learning, but we would love to hear your thoughts on them, so do please get in touch. In today's video, I'm going to be reviewing 2 recent cases which may herald the emergence of a new morality in English contract law, and then considering their potential impact for banks and financial institutions. The first, Barclays Bank and UniCredit, introduces an objective standard of reasonableness into financial transactions when deciding whether consent to the early termination of certain guarantees has been reasonably withheld. And the second, Yam Seng, an international trade corporation, introduces an implied duty of good faith of general application into English contract law. Clauses conferring on one party the discretion to consent to a request by another party are common in finance transactions. It had previously been held in a 2008 decision of the Court of Appeal, Sosima and Standard Bank, that when one party to a contract has the power to make decisions that it may affect both parties, the party exercising such power is required to do so honestly and in good faith, and not arbitrarily or capriciously. There was, however, no requirement that the exercise of such power should be objectively reasonable. That position would now appear to have changed as a consequence of the Barclays Bank decision. In September to December 2008, at the height of the financial crisis, UniCredit found itself needing to improve its capital ratios. To do this, 2 of its group companies entered into synthetic securitizations of their loan portfolios by way of 3 guarantees. Under the guarantees, UniCredit transferred some of their credit risk to Barclays, in return for which Barclays received quarterly premium payments and fees. One of the 5 contractual optional early termination clauses gave UniCredit the option to terminate the guarantees in the event of a regulatory change resulting in less favourable capital treatment of the guarantees. UniCredit was required to seek Barclays' consent to early termination, and Barclays was required to consider the issue of consent in a commercially reasonable manner. In 2010, and as a result of a qualifying regulatory change, UniCredit sought Barclays' consent for early termination, but Barclays refused to consent unless it was paid the equivalent of 5 years' fees. This was the amount which Barclays had calculated that it would definitely earn when it entered into the guarantees, and which it had booked as profit at the time. Barclays further maintained that it and UniCredit had shared a common understanding when the guarantees were entered into that if an early termination request was made, Barclays would only consent upon payment of 5 years' fees. In any event, UniCredit considered Barclays' refusal to be commercially unreasonable and discontinued payment under the guarantees. The court found for Barclays, holding, first, Barclays' determination of whether to consent to early termination for a regulatory change had to be commercially reasonable in an objective sense. It was not sufficient for Barclays to show merely that the decision was made in good faith and was not arbitrary, capricious, or irrational. Second, Barclays needed to show that a reasonable commercial man in Barclays' position might have reached the same decision. Third, in determining what was commercially reasonable, Barclays was entitled to take into account its own commercial interests. These took precedence over UniCredit's commercial interests. Barclays was not obliged to balance its interests with those of UniCredit. Fourth, Barclays was entitled to ignore the effect of the continuation of the guarantees on UniCredit, unless the nature or amount of Barclays' fee income was so disproportionate to UniCredit's obligation to continue to pay that no commercially reasonable man in Barclays' position could have refused consent. Turning now to look at the Yam Seng decision, as you will probably be aware, the English common law has traditionally been very reluctant to recognise the principle of good faith of general application. This is in distinction to many other jurisdictions throughout the world, including the majority of the EU member states. In the United States, the principle is enshrined in the Uniform Commercial Code. The existence of a contractual duty of good faith has also been recognised in Canada and Australia. Until very recently, therefore, English law was the outlier. Absent in certain limited categories of contracts, such as employment contracts and partnership agreements, the English courts were reluctant to imply any duty of good faith or fair dealing. That is not to say that the English courts does not give meaning to overt contractual expressions of good faith. In CPC Group and Qatari DR Real Investment Company, where there was an express contractual duty of good faith in issue, Mr. Justice Voss held that it comprised an obligation to observe reasonable standards of fair dealing, to be faithful to the agreed common purpose, and to act consistently with the justified expectations of the parties. However, the traditional English law hostility to the implication of a duty of good faith of general commercial application may now have fallen away as a result of a decision of Mr. Justice Leggett in Yam Seng. The case did not relate to a finance transaction, but instead related to a distribution agreement for Manchester United branded fragrances, deodorants and other toiletries, pursuant to which ITC granted distribution rights to Yam Seng in Asia. Following a breakdown in the relationship, Yam Seng terminated the agreement and brought a damages claim in the English High Court. Yam Seng claimed that ITC had breached an implied term that the parties would deal with each other in good faith. The court found for Yam Seng. The facts may be important, but it is the judge's discussion on the implication of a duty of good faith which is most interesting. In headline terms, he saw no difficulty in implying a duty of good faith into any ordinary commercial contract based on the presumed intention of the parties. The judge approached the issue as one of construction. His starting point was that contracts were made against a background of unstated shared understandings which informed their meaning. The relevant background against which contracts were made included not only matters of fact known to the parties, but also shared values and norms of behaviour. A paradigm example of a general norm was an expectation of honesty. That expectation was essential to commercial relationships, which depended critically on trust. As a matter of construction, therefore, it was hard to envisage any contract which would not reasonably be understood as requiring honesty in its performance. However, the judge went on to say that what good faith required was sensitive to context. It included the core value of honesty, but in some contractual contexts could also extend to an expectation that the parties would share information relevant to the performance of the contract. And this was particularly so where the relevant contract included a longer-term relationship between the parties requiring a substantial commitment. That said, the test of good faith was objective, in the sense that it depended not on either party's perception of whether particular conduct was improper, but on whether, in the particular context, the conduct would be regarded as commercially unacceptable by reasonable and honest people. In the judge's view, therefore, there was nothing novel or foreign to English law in recognising an implied duty of good faith in the performance of contracts. So, looking into the proverbial crystal ball, what are the practical implications of these decisions? The English courts have traditionally valued certainty over fairness in contract law, in distinction to civil law jurisdictions, where principles of fairness often come much higher up the pecking order. It is the case that these decisions do introduce an element of uncertainty into the determination of contractual disputes, but the extent of such uncertainty should not be overplayed. The facts of the Yam Seng case were extreme, and the real impact of the decision may be a little more than a heightened appreciation that contracting parties must deal with each other honestly and perhaps a little more openly, and in appropriate cases involving longer-term or relational contracts, possibly extending to facility agreements and syndications, sharing relevant information more willingly. However, the Barclays decision is of more immediately obvious significance. Clauses conferring on one party the discretion to consent to a request by another party are common in finance transactions. Such clauses often, for example, provide that consent should not be unreasonably withheld. As a consequence of the Barclays decision, the party determining whether or not to give its consent will have to act in an objectively reasonable manner. Banks and financial institutions will, however, take considerable comfort from the court's welcome clarification that determining consent, or for that matter taking any other action, does not require the determining party to subjugate its interests to those of its counterparty, or indeed, absent very obvious disproportionality, even to balance its interests against those of its counterparty.